Hello guys, Anmol here from Paris and Baz Real Estate. Today we are joined by Jacob Bozdas from Norwest Law Group to bring to you another episode of Paris and Baz Cast. So as you've seen, this is actually our 10th episode. So really grateful for a number of guest speakers that have been on so far. So it's great to see the traction there. And today's topic of discussion is reading a contract of sale. A lot of you who are new to the market, looking at entering the market, would be collecting a number of these at open homes and looking at different sections and what they exactly mean. There's easements, covenants. There's a whole heap of topics of discussions coming through. So without further ado, let's get started. Welcome Jacob.
Thank you very much.
Thanks for coming.
Thank you for inviting me.
So just a bit of a brief introduction about yourself.
Sure. So I've been a solicitor for almost 15 years now, worked in various law firms in the CBD. Opened up my own practice almost 6 years ago in Norwest, and I've been practicing primarily in property law, enjoying it since then.
Yeah, very good. So basically, reading a contract, it's a hot topic when everyone wants to buy a property. Contract to sell is the main thing. If we start off from the inclusions,
what to find in the property. So what are the different sections that you can find?
So inclusions will be specified on the front page of the contract. So ordinarily blinds, fixed floor coverings, dishwasher, microwave, stove, things like that will be marked, literally marked on the front page of the contract. And I suppose from a purchaser's point of view, it'd be a good idea to make sure that the condition of these inclusions are satisfactory. I suppose that's when a pest and building inspector might be handy at that point.
And with the actual sections of the contract, so obviously there's the first page, then there's the general terms and conditions, if that's a standard contract, plus any special conditions, or what else is you find?
The structure of a general contract is the front page, as you know, standard terms is mentioned, the special conditions basically, which is drafted by the solicitor or conveyancer, and that's the part where we focus our attention on. And then you've got all the prescribed documents, so the title search, and if there's any sort of restrictions on the use of the property, if there's any easements, those types of documents must be attached to the contract, along with a 149 planning certificate, which is a council certificate that indicates if there's any road widening works or if there's any proposals to develop the area or neighbouring properties. So that's the general structure of a typical contract.
And also on the front page, there's normally a box that's vacant possession or existing tenancies.
Correct.
Could you just provide a bit more detail on that?
Yep. So front page, it'll either be marked vacant possession or it'll be subject to a tenancy. And that's important because obviously it's a purchase of one's vacant possession. That should be marked. I've had one case where one of my clients actually wanted to purchase the property with vacant possession, but the front page was marked subject to a tenancy. Although the agent promised that the tenant is to leave before settlement, for some reason the tenant actually renewed their tenancy agreement, and legally we couldn't do anything about it because on the front page it was subject to a tenancy, irrespective of whoever the agent, whatever the agent said to the purchaser.
So that's something to look out for.
Yes.
And if we move on to easements, this is always a hot topic when we look at a contract. What should we look out for when we look at easements for a buyer?
So easements are typically, what is an easement?
Exactly.
What is an easement? A typical easement, it would be a drainage underground, under the actual soil, usually located either the side of the property, boundary fence, or the back of the property. So by way of illustration, just to make it simple, this is just a basic illustration. That's the property here. And you'll have a red line there at the back of the property, which will be the easement, the drainage itself. What does that mean for the purchaser? It means that you cannot build any structure on top of that easement. So if it's not an issue if the purchaser had no intentions of building a granny flat or a shed at the back of the property, no problem. But if the intention was to build a structure and there's an easement there, well, they're going to have problems and council will most likely not allow it.
True. Especially if and also I think when it comes into play when there's zero lot allotments and you can't build over it.
Correct.
To the edges.
That's right.
So what is a zero lot for those that don't know? What's a zero lot?
So a zero lot basically means the actual the wall of the property is very, very close to the boundaries. It's usually within half a metre or a metre. And
there's no boundary fence basically.
There's no boundary fence basically, or could even be a shared wall basically, like a duplex. So zero lot, usually very small block of land. And you can only build a specific kind of house to fit into that zero lot property.
So an example of that would be, so for example, if it's a 10 metre frontage or shorter, that's usually around, I think we've seen a lot around Box Hill, around Marsden
Yes.
Park,
the new
Schofields.
developments that are
They
happening.
allow you to build right to the edge, so it allows you to maximize the space. And normally this sort of land size is about 250 to 300, so talking about sort of entry level
Correct.
homes there.
That's
Yeah.
right.
And if you move on to restrictions of land, what do they normally entail?
Restrictions on the use of the land, for example. So a typical one would be a vacant block of land. Okay, so there's a contract for that. And if you look closely to the contract, there could be a restriction for the purchaser to use a specific builder.
Yeah.
Okay, and it's going to be specific pre-made architectural designs.
Yeah.
So if the purchaser is not interested in those kinds of designs or that builder, it's a problem.
They should be aware of it.
They should be aware of it, basically. So I've
had.
had a client recently, actually, he was looking to build his own home on a vacant block of land. Until I reviewed the contract and told him, well, hang on, this contract tells me you have to use that specific builder. And he wasn't interested in that. So I picked that up, and he was very happy that I did, and he didn't proceed with that. He found a different block of land that didn't have that restriction.
Yeah, sure.
Very good. And also in terms of pool compliance, when there's a swimming pool in the house, there's registration that needs to be done and compliance.
So there's been recent legislation with swimming pools where one or two documents must be attached to the contract. It's compulsory. It's either a certificate of compliance, which tells us that the pool is compliant, no problem, great. Or if it's not compliant, then a certificate of non-compliance must be attached to the contract. What's a non-compliant swimming pool? There's no fence, the fence is damaged, child safety issues, the lock is not there, all sorts of issues. And if it's non-compliant, what does it mean for the purchaser? It means the purchaser will be obligated at their own cost to rectify the non-compliant areas within 90 days from settlement date.
Wow, okay.
So when purchasers are looking to buy a property or swimming pool, if it's non-compliant, then you'd be wise to sort of consider the cost of rectifying that.
Because the onus is on them once they bought the property to fix it.
Correct. Yes.
Right. And also another commonly asked question is land tax, land tax adjustment. How does it work and how is it calculated?
So land tax typically applies to properties that are owned by investors because land tax is not applicable to your principal place of residence.
It's exempt,
So a typical person, he owns his own home, lives in it, but he owns several other properties as investments. Depending on the threshold, that vendor might be paying land tax. And in the contract, there's an option where land tax can be adjusted in favour of the vendor and payable by the purchaser. So, for example, land tax is assessed from 1 January to 31st December. If it's $1,000 land tax that the vendor pays, for example, and say settlement is in the middle of the year, 30th of June, and the contract allows for that adjustment, then basically $500 will be added on top of the purchase price by way of an adjustment payable by the purchaser. And obviously that's one of the things I'll look out for, and if it's applicable, then we try and negotiate that it's not adjustable in favour of the vendor.
That's very interesting to know, especially if you already own a property, it's investment or
correct.
vacant
And it could be
property.
quite significant sums too. So
Depends how many properties that person has and
exactly.
Any other questions?
So in terms of so let's say, and it's just going back to basics again, focusing on those that haven't purchased before. So from a purchasing point of view, can we just give a rundown of what exactly happens? Obviously, you've got the contract of sale. It then goes to the other side, so the buyer's solicitor, who then review. You sign the contract. What happens? Do you want to talk about?
So typically what happens is, the purchaser finds a property, makes the offer, the offer is accepted by the vendor and the agent, the contracts are prepared, and basically we look to exchange contracts, which literally means the purchaser signs one copy of the contract, the vendor signs one, dates it, it's physically exchanged, and the respective contracts are gone to the respective parties, solicitor or conveyancer. After contracts are exchanged, it'll be dated, and the typical settlement period will be 42 days, 6 weeks after that period, after the exchange date. During that time, the solicitor will be conducting the due diligence, ordering certain documents to ensure there's the council rates notices, water rates notices, if there's any potential future development approvals in nearby areas that may affect that property as well. I've had one sort of matter where one of my purchasers, he's actually exchanged contracts. He's at the 5 business days cooling off period, and then upon further investigation, we ordered a search, a development approval search, whereby the next door neighbour was to be converted into a a homeless shelter
Right.
for people. So
okay.
that may not be very appealing for some purchasers that live in that property next door.
Yeah.
So I advise the purchaser, he pulls out of the contract.
Yeah.
Probably saves him a lot of grief
Yeah.
because he's got a young family himself.
Mm-hmm.
So that's the general process. Settlement 6 weeks. We settle, and then the purchaser becomes the new owner of the property.
Yeah, exactly.
Yeah.
And from a vendor's point of view, and it's something that normally just gets asked from a cost perspective. Can you just give us a rundown of, say, when a vendor provides instruction to solicitor, what happens in that period, and approximately what sort of the general fees involved?
Sure. So for a typical freestanding home, the documents, these documents called the prescribed documents, they must be ordered. And these are as I said, copies of easements, or if there's restrictions on use, the 149.
Yeah.
That costs money to order. Typically between $300 to $500.
Yeah.
For
upfront.
For ordering those documents.
Yeah.
For strata, it could be different depending on if there's any strata plans registered, or if there's any additional bylaws registered.
Yeah.
For a freestanding home, expect between $300 to $500 upfront to order these documents.
Yeah, okay. Well,
That's good.
and then the balance is sort of anywhere from
And
$750 to $1,000.
Balance is payable on the settlement date, basically. That $300, $500 simply covers the solicitor's cost of ordering those documents. And then disbursements, basically.
And going from there. And the other question we also get asked is caveats. What are they, and how do they impact the property?
Okay, so what is a caveat? A caveat is placed on the title of the property. It has to be placed by a person that has a caveatable interest in the property, which means that that person has some kind of equitable or legal interest in the property. They register the caveat and title, and that caveat, once registered, simply prevents the sale of the property. Until that caveat's removed, the property cannot be sold.
Yeah. And what's an example
of a caveat?
Yeah.
Well, a typical example, in a scenario would be, a husband and wife are, going through divorce proceedings, and one party is concerned that the other party will quickly sell that property, extract the funds, and take the funds.
Yeah.
Whereas the other party, if they place a caveat on title, then that other party cannot sell the property without removing the caveat.
Yeah, sure.
Yeah. So
there you go.
Gives you
a bit more. Yeah, okay, perfect. Is that everything? Is that another?
Oh, yes. Well, this was just the simple
example.
That was the illustration I showed earlier.
Yeah.
This is the kind of plan that you will find in a contract that is an easement. So this is the property here. That's the front there. That green line there will be the easement, will be a drainage or something like that.
Yeah, and which is common. So a lot of people, when they hear the word easements, they get scared of what exactly it's going to stop me from building it. But you have to realize this, as long as it's not running through the middle of the lot, it is on the sides, and depending on what you're actually doing or planning on doing with that particular boundary, whether it's a granny flat or a shed, it doesn't really impact you negatively. So it's not something to be concerned about.
And it should be noted that there are different types of easements as well.
Yeah.
So that's one example.
That's just one.
A typical one will be a right of carriageway, which basically means that the neighbour might have access to walk through that property and enter the next property.
Yeah.
So it's a right of carriageway.
Yeah.
Not very common.
Yeah.
But that generally happens when a particular lot is locked into boundaries, and they must access another property to access the road.
Go there,
so
sure.
Right of carriageway, aka easement.
Yeah, and even is it from an electrical point of view, or the government having access to?
Yes, electrical points, drainage points. The government
sewage,
may need to access the sewage.
Yeah,
it's fairly common. It's very common.
So it's nothing to be concerned about.
Yeah.
There you go. Well, thank you so much for your time. Really appreciate that there. If there are any other questions, please do feel free to enter them into the comment section or reach out to us. The beauty of Jacob being in the same building means we can communicate quite regularly and get those questions answered for you. And for the next lot of Paris and Baz cast episodes, as you know, this is a weekly episode we bring to you every Thursday at 3 p.m. I'm just going to run down a couple of people that we have locked in that are coming through. And if there is anyone else that you think would add value and would be a great addition to the panel, as we're calling them, please feel free to reach out to us for that also. So next week, we've got Ben Plow, who's actually watching, I believe, as well, to talk about borderless investing. So sort of looking outside your backyard, so in different states and what the opportunities there are there. Then we've got Stu Benson, Hills District's renowned auctioneer, that's going to be coming to talk about the whole process of auctions and sort of demystifying that, because there's a lot of stigma attached in some ways from a buyer perspective as well. So that's going to be coming up on the 11th of July. Then from a lot of those buyers or the landowners that are looking to own a build, we're going to be discussing that with James from Rising Eagle Group about what to look out for when you're selecting your subcontractors. And we've also got Oliver Jackson from Living Property, who's going to be looking at what renovations will actually add value when you're going to sell a property. And in between, I think we've also got Deposit Assure. We're just confirming that with Louise, who's going to be talking about if you don't have enough deposit for a property, how they can help at the time of settlement. So stay tuned for those ones, and we will see you guys next week at 3 p.m. Thank you.